So thank you, ladies and gentlemen, for staying with us to this, the last panel of the day. I do know that the SFC's secret trick to making sure that people would stay was to have the head of enforcement and the head of intermediary supervision here, so there would be a sense of obligation. But nonetheless, we thank you for staying. Ordinarily, when I'm on a panel that is the last in a full-day session, I hope that people would have been properly caffeinated during their coffee break. But after the last panel, I actually hope you had a nice cup of chamomile tea to calm down. Those of you in the room who are from the world of intermediaries would know that the introduction of the manager-in-charge regime last year represented a fairly significant development in the SFC's approach to supervision. And there have been a number of reasons for the enforcement side of the SFC to be in the news in recent months, and indeed even in recent days. This panel will look at these and other aspects of the SFC's efforts to ensure compliance and to deter market conduct. In addition, we will also, as a bonus topic, be looking at how the SFC is keeping up with technological changes. We have an excellent group of panelists with us here today to cover these topics. At the far end, Tom Atkinson, a Canadian import to the SFC, is the Executive Director of the SFC's Enforcement Division and also former Director of Enforcement at the Ontario Securities Commission. Andrew Procter, a partner in the financial services and regulatory practice of Herbert Smith Freehills, was, among other things, with the SFC from 1996 to 2001, where his last position was Executive Director of what was then the SFC's Intermediaries and Investment Products Division. Julia Leung, the Executive Director of the Intermediaries Division, and as of just very recently, the Deputy CEO of the SFC. Congratulations, Julia.
Thank you.
She is also the former Undersecretary for Financial Services and the Treasury. And lastly, I have Dr. Greg Chu Gang, COO of China International Capital Corporation Limited. Greg is also the chair of CICC's Capital Markets Committee. So in this panel, we are aiming to divide our discussion into four main topic areas that we will cover in succession. These are: 1, senior management accountabilities and responsibilities; 2, corporate fraud and market misconduct or market manipulation; 3, communication, collaboration, discipline, and deterrent; and lastly, keeping up with technological developments in financial services. Rather than begin with opening remarks, we'll go right into the questions. So, on the first topic, senior management accountability and responsibilities. Julia, let's start with you, and perhaps you can just address what do you believe the SFC is trying to achieve with the MIC, and do you believe you're getting the results that you were looking for?
When we were, the idea of having an MIC regime is actually to enhance accountability for those responsible for the operation. Now, when we were conceiving the precepts for MIC, at that time we were trying to address a few issues that we see in governance and in the market. First of all, we're not getting, SFC, the licensing department is not getting structured information, management information, meaning in a standardized format of who's in charge, who's in charge of these key business lines. And secondly, we already have our regimes, not as if we can't hold people responsible, but as it evolved, we find that people who are appointed RO may not be those people who are calling the shots and being the decision-making most important business people. And then we're also getting a lot of boards which are not really populated by people with real responsibility, more like a paper board. And of course, we already have the liability provisions in the disciplinary chapter of SFO, but then the issue is, if you're trying to investigate into a case and we're trying to find out who was actually in charge 5 years earlier, you might not be able to really pin them down. So, what we did is, the rest is history. We wrote out a circular. It was launched in April, and then it's fully implemented by October of last year. We got all the structured information. And to your second question, what we've seen when we go through all these data and information, the governance and management structure is clearly much, much better. We've seen boards, they are filled with people who are MICs. The job responsibilities, particularly for firms with local subsidiaries and global, in a global organization, they're very clearly delineated. And some of them actually put in operating committees and fill them with MICs so that they can make better decisions. So the governance structure is definitely enhanced. And we also see a much, much better alignment of senior management with the ROs. In fact, we've seen applications, RO applications, 1,300 RO applications coming from OMOs or the MIC of the key business line, which is our expectation. We want those people who are in charge to be an RO of the key business lines. And altogether, we only have 7,700 ROs. So I do note that some of them will need to sit for exams at a very mature age, but then that's that's to be expected. And best of all, what we're trying to do by making, knowing and having this structure is actually to drive behavioral change. And to do that, we heighten, I guess, by being nominated and designated MIC, you certainly are much more aware of your responsibility that comes with that, your accountability comes with that. And I've seen training sessions being, and I was told by a lot of compliance officer, I mean, including some in this room, who told me that, well, it really makes a difference, so.
Greg, first of all, thank you for being willing to join this panel as one of the licensed entities that is accountable to the SFC. Let me ask you from your perspective, what is it like to comply with the MIC? And I should ask you, first off, are you an MIC?
Yes, I am.
Excellent. And what has the experience been like for you? What were the challenges?
Sure. You know, I think from an industry's perspective, this is how I see things. I think from the world financial crisis, is now consensus that financial institutions need to be run at a higher standard. And regulators from the UK, US, and EU have all introduced tighter regulations. And a tighter regulation is a trend worldwide. And this is not something just required by the regulators. This is there are serious discussions at board meetings. This is requirement by the stakeholders, and requirement, demand actually of the society at large. So now the question is, how do we run a financial institution to a higher standard? This is obviously a very complex issue, and I don't think there's just a silver bullet. So you can list a lot of things that we need to do. We certainly need a clear organization, a better governance, and you certainly have individual accountability. And you can talk about culture, you can talk about separation of roles, you can talk about independent functions of your company, you can talk about transparency and timely flow of information, and you can talk about your compensation promotion practices. But I think one thing stand out is a clear management structure and individual accountability. I think that's how I view how SFC has introduced its MIC regime. And I think this is especially right for Hong Kong market. I think in terms of intermediaries in Hong Kong market, the mix has been changing. You certainly have global firms which have strong connections to their home countries and regulators, and they have very complex business in Hong Kong, and they have matrix reporting format. and they have a strong culture and all of that. And you have local firms, the business model tend to be simpler and relative small. And now, additionally, you have a large number of mainland firms coming into Hong Kong market. They are in the various stages of development and in terms of business complexity, and also a different kind of experience. So now the question is for the industry as a whole, how do you actually enhance local entity governance for the global firms and for everybody, and also for mainland firms? For mainland firms, most of the mainland firms structurally they focus on entity governance, but on the other hand, the experience that they have, and in terms of executive experiences are actually very diverse. I think the focus on local entity governance, clear management structure, and personal accountability is actually the key. So we're very happy. It's actually help us. I obviously sit in Beijing. I want to make sure our Hong Kong operation is up to standard. So I felt this is really very helpful for us to roll out all these practices. And for us, our experience is, in the past, our business tend to be relatively simple. We focus on institution business. We actually focus on fee-generating businesses. But now, over the last few years, our expansion, our business is getting more complex. We are dealing with a lot more individual wealth management clients. We are dealing with a lot more sophisticated product. And we are using balance sheet to do transactions on behalf of our customers. So with all these changing, we need to move to a higher standard. So that's why we felt, you can't have managers hide behind ROs, and so we felt, we actually roll out, this regime. We think it helped us tremendously. And in terms of behavior, I start to hear, our IT chief start to become anxious. I think it's good. I think it's good. So I thought this is really healthy for our industry, and for me personally, for our operation in Hong Kong, I feel a lot at ease.
Let me ask you, what is the biggest challenge? Is it having those difficult internal discussions where somebody has to accept responsibility that maybe they felt was either not theirs before or ambiguous previously, or is it studying for those exams?
I think for many people, certainly many of the managers actually they are ROs and they're doing their jobs, but as business evolved, their understanding of the whole picture may not up to par. So with this clear understanding that you are the person in charge with the whole picture of this particular function, really help them to understand their responsibilities better. I think it also helped them to grow from a regular person, special focus on special aspect of business, to a person who actually become a manager. So for us, obviously, many people may not willing to move in that role, to have a lot more responsibility. It takes some persuasion and takes some, very, sometimes it's just command for them to do it. But at the end of the day, it was done.
I think it takes persuasion, but also a monetary reward. So here that there's a premium for being an MIC.
We will be talking about carrots versus sticks a lot, I think, in today's discussion. But Andrew, I wanted to ask you, given that you have an interesting perspective, not only having served in the SFC, but also in ASIC as head of enforcement, in the FSA in the UK as head of enforcement, and also in the intermediary side, working in compliance and regulatory affairs with Deutsche Bank. So in your view, how does the MIC regime stack up against its peers in other markets, and particularly the SMR in the UK or the BEAR in Australia?
Yeah, Peter, I think Julia did a very nice job, actually, of introducing the changes with a minimum of complexity, but covering a very wide range of firms, as Greg has said. The UK produced literally thousands of pages of consultation. There are already 4 versions of the senior managers regime, and they've not yet rolled it out to the 50,000 non-banking firms. Julia produced 23 PowerPoint slides, and one of them was any questions. So it was a model, actually, of how things can move in Hong Kong very quickly. There's one downside risk of that approach, and it's one that Julia and I discussed. Every bank that I've advised in the UK and firms here in Hong Kong and now in Australia hates doing this. They all come out of it better, but they hate doing it. And they have to be dragged from where they are to where they need to get. And so there are times when a level of prescription is actually a good thing, because they come back to you and say, do I have to do this? Am I required to do this? Where is that? Now, what Julia did to cover the field was a very simple requirement around the alternative to what in the UK are the responsibility maps, and in Australia the accountability maps. Not as much prescription in either of those other 2 jurisdictions, but they are the key documents. They're the documents that forced people to really think how things were done around here, and to focus on ambiguities, uncertainties, lack of clarity, and to think about whether there was a consistency in governance. It goes to all of the points around the matrix that Peter touched on, group versus local, etc. That's not in the Hong Kong regime. So what Julia had to do, and what I think she has done, is calibrate a very simple one-line requirement for complexity in the firms. Now, she's going to have to hold them accountable for that, and certainly in the UK, 18 months in, it's already time to go back and review how firms are doing and how they're implementing, and to look at the kind of reasonable steps that senior managers are taking. And so that will be a process of renewal. The other thing you see that's completely consistent around the world is that people who are Tom's peers say exactly what Tom says. This is not an enforcement-led program. It's about governance and it's about clearer accountability in order that people will do the right thing and they won't need to go to enforcement. It's too early to judge whether that's true in other jurisdictions. In fact, in the UK, there hasn't been an explosion of cases against senior managers yet, although who knows what Mark Stewart might have up his sleeve. But if that is to be true, if it's to be true that it's not an enforcement-led program and it is about doing things better and about prevention, then the senior managers or the managers in charge or the accountable persons in Australia in all of those jurisdictions will need to be given space to do the things that's expected of them. And when something goes wrong, not to immediately be dragged into enforcement. There has to be more space than I think has been true in some jurisdictions for some time for a supervisory dialogue between senior management and the regulator.
We will get to dialogue as I think part of our third topic, so thanks for bringing that up, Andrew. Meanwhile, I'm going to turn to Tom as we segue into the next topic on corporate fraud and market manipulation. Tom, the SFC made some headlines in December with some arrests that have been referred to in earlier sessions, together in cooperation with the ICAC, involving what you have referred to as nefarious groups of interrelated companies that work in coordination to extract value from unsuspecting investors. Are there any lessons from what you did in that particular case?
I think when I look at those cases, well, one thing that's been very good is it's allowed us to collaborate with our other regulatory partners within Hong Kong. And this was a purposeful strategy that we wanted to work better with the police, better with the ICAC, better with the HKMA. We've done all 3 of those things. And I think, where the ICAC's, looking at corruption or bribery, our roles overlap somewhat when we're looking at corporate fraud. So there's a meeting of interest there. Very professional group. And we've dealt with it quite well. So I think on our recent actions that we've been dealing with, we're learning, and it is a learning process. But we're learning how to gather the evidence better. We're learning how to identify our targets better. We're learning how to analyze and understand the evidence, we're seeing better. I think any of those people that are, making ill-gotten gains, their life is going to get very difficult very shortly. So I think we're going to get very good at detection and dealing with these people. So but I do think it's a learning, and we'll go, and as we see more cases where our interests overlap with ICAC or the police, we'll pursue those cases.
There will be some people who look at that arrest and say, what took place in December was great, but it happened some 6 months after the big stock market sell-off, where a number of these companies' stock prices fell precipitously, some up to 90%. Could anything have been done sooner? What are the challenges to trying to take quicker action?
Well, a couple of points I'd like to make, because I think that's fair, and I think enforcement takes a long time. But you've heard the other panelists today talking about how proud we are of the rule of law here. We have procedural fairness to follow. We just can't go on whims. We need actual evidence. We need evidence that's admissible in court. You've also heard, Brian talking about why it's so important to us to have this front-end loaded approach on some of these IPO problems, because enforcement's really, it is a slow process. It's an expensive, slow, cumbersome process, and we move it as quickly as we can. We've done a number of things to improve the speed of overall in terms of enforcement. We've shifted a number of resources from what we consider low priority matters to high priority matters. And so, for example, we have a corporate fraud group, we have a corporate malfeasance group that are strictly focused, and we've put a lot of resources into that. And those teams we set up, I think they were in November 2017, so they're just starting to gain traction now. And they're gaining traction quickly, and you can see the actions are starting to come out now. I think we, in 2017, we banned something like 27 directors in the whole year. Last month, the board approved that I take action against 23 directors. So we're moving very, very rapidly, but it is slow, and we're just going to have to continue to try our best to go as quickly as we can.
Andrew? Just make an observation about that, Tom. I think that the challenge here and elsewhere is knowing what's out there, the intelligence aspect of it. And I get a sense, talking to regulators around the world, that more will need to be done to just keep up with cyber criminals, for example, who are often backed by government. I checked out the FBI's 10 most wanted cyber criminals recently. 7 of them had state backing. And so it's very tough for an individual regulator to know what's out there and to be on top of the intelligence. It's actually even tougher for the banks and firms. And, historically, notoriously, those firms who make filings in respect of suspicious transactions or potential money laundering never get any feedback. They don't get intelligence. I think it's a real area where the group of regulators, of which you're one, and the heads of enforcement in particular, could potentially do more to share intelligence and to get an earlier insight. Yeah, and if I could just pick up on that, we actually are doing that. Actually, 3 weeks ago in Montreal, all the directors from IOSCO, or all the IT people attached to enforcement groups, met to talk about sharing intelligence data. And the SFC itself has a fairly large data project going, where Keith Liu is looking at systemic risks, Julia is looking at prudential risks, I'm looking at conduct risks. The problem is when we're looking at the available intelligence out there, there's so many new reg tech firms, you don't know what's leading edge, bleeding edge. And what we've done to discipline ourselves is we've picked sort of 9 conduct issues where we're asking ourselves, what more information could we have to have more transparency on a problem? What would allow us to make more connections between people, entities? And so we're starting with what we have, the information we have within the SFC itself. So we're looking at a project now to sort of digitize that information and be able to read it. Second of all, overlay market data on top of that to help
with that. So the intelligence is coming, and it's fairly new, and it's moving fairly quickly. So I think it's going to take a while, but we could definitely do better in terms of intelligence, and I think that's coming in. We know from all the other regulators in the world, they're all basically at the same point. Some are a little bit, maybe 18 months ahead. That's about it.
Yeah, 18 months ahead in expenditure, but not success.
Yeah.
Yeah.
Tom, you mentioned IPOs. I wanted to dig in a little bit on that topic. One of the items that's brought the enforcement division into the news just recently involved IPO sponsorship.
Right.
And a certain Swiss firm in the market that was banned from IPO sponsorship for 18 months. I think last year the SFC announced that there were 15 sponsors of capital market deals that were under investigation. Could you tell us a little bit more about where the SFC is on that?
Sure. So I'm not going to speak about any specific investigations, but we were investigating 15 sponsor firms. We've issued 8 proceedings against those firms, and now we're looking at the sponsor principals, and we're moving against those. So that'll be another round coming out. They're all starting to come to a head now. But they still, we issue an NAPD. They have a chance to reply to that. Then we issue a decision notice. They can appeal that decision notice. Again, it's enforcement. It's not the quickest process. But our hope in bringing, and they're all at different spots. Some of it's negligent. Some of it's what I would consider extremely reckless conduct. It's all at different spectrums. So there's all a different range of sanctions that we would seek on each of them. So that's where that's at. So it's starting to come to a head now. I think over the next 6 months, you may see some of them either resolved or going firmly onto a hearing. But I think we've really set the tone in terms of sponsorship, and I hope we're raising the bar because I do think there's what we're trying to show people is there's serious reputational damage if you don't do your job. So that's what we're trying to get across.
And on that point, actually, maybe Julia, if you want to jump in.
Tom cannot talk about case. We can talk about our recent thematic review inspection findings. We conducted a review and inspections on covering 31 sponsors, covering the work from the period of 2013 to December last year. And if you were asked whether there were improvement or there were continued deficiencies, I would say there are continued deficiencies we found in the sponsors' work, and particularly in the area of performing reasonable due diligence, as you expect. This is certainly one of the key areas. Now, you asked, what do you mean by not reasonable? What kind of work is reasonable? Now, obviously, when we go about looking into those transactions, obvious red flags been ignored. Now, so many of these red flags would have become very obvious. Like, for example, you cast doubt on the genuineness of the customer, whether they are actually having that kind of sales to their customers. Our team would look into payments and invoices, and if the payments and the shipments do not reconcile, that's an obvious red flags. And there's a lot of other errors and material discrepancies between those payments, or maybe it's made to the third parties. Those are things which we should raise concerns. And again, we see a lot of over-reliance on third parties. Like if you are asking third parties to do the due diligence. Now, we are not saying that you cannot do it, but you have to understand sponsors cannot abrogate their responsibility for due diligence, and they still remain responsible. Now, they can't really just rely on the third party's work, legal opinion, or investigation report as evidence that they have discharged their duty. They probably should be setting the scope of the due diligence. They should be giving a lot of guidance. They should be, when the results come in, they should ask questions. So these are the things that we will be looking to see if you have actually take the responsibility. Another area would be insufficient management responsibility, management supervision. Now, our number of sponsors have grown from something like 75 in 2012 to 107 right now. And many of them are small ones. The new ones are small ones, which are sponsors for GEM companies. And some of them are very aggressive in taking on new business. I mean, as soon as they get the license, they would take on like 6 or 7 IPOs. And with only one person, one sponsor principal responsible for 6 or 7. So we really would question them. And an indicator that these are substandards, we see that from 2013, a total of like 44 listing applications were returned or rejected due to concerns by regulators, not because of a timing issue, not because of the withdrawals, not because of the listing applicants changing their mind, it's because of substandard work. So what we do is if we see a sponsor which have a number of cases of return work, certainly that would call for us to conduct a more frequent inspection on the firm. So we will be issuing a circular along with a thematic report because we want to illustrate with cases and examples of where due diligence has not been done, and also we will be reminding the sponsors of the interview practices, how the need for verification and how you verify, the corporate governance, the resources and system to go with it. So I think the report and the circular will probably be out later this month.
Happy to add.
Greg, do you want to jump in?
We are certainly a sponsor firm, and the news of the last week is a good reminder that even some of our industry leaders, actually struggling to face a lot of challenges here. And in Hong Kong market, as we saw, many years ago, a lot of mostly SOE firms are coming in, and now there are a lot of private companies coming to this market, and so there will, now there's pre-revenue firms as well as tech firms in the process of coming to market as well. And I think corporate fraud and market manipulation is a global issue, but I think especially true for China. China, as we know, is experiencing a historical social transformation, from a basically agriculture-based economy now to a industrial, urbanized country where a lot of new business is springing up and things that happen at breakneck speed. China hasn't got enough time and a well-groomed system to get rid of all the weeds. So that's why we actually had to set ourselves to a higher standard, to be very selective, to do our due diligence better, and performing our functions. Obviously, with expertise and with all a lot of details that Julia mentioned. I just want to add that the news that came out is a good reminder, and that we as an industry should be on our toes. We should be vigilant. We should we should constantly remind ourselves that this is a tough challenge. Even some of our leaders in the industry can fail, and the failure can be detrimental. I think those kind of attitude, it's also going to help.
It was interesting to note, Julia, from your comments that even after it was widely known in the industry that a number of sponsors were being investigated, that the results of this thematic review suggested that maybe not all of the lessons were being internalized. So, Greg, I mean, maybe can you speak to this? I mean, it's when you're dealing with emerging markets and many of the listings coming to Hong Kong are essentially coming from emerging markets, particularly mainland China. It's often difficult to do due diligence properly, and sometimes that line between just not doing enough work or perhaps willfully looking the other way is a little bit hard to identify. How do you ensure that people are really taking these lessons to heart and doing the work the way the SFC expects them to do it, and the way you expect them to do it?
I think really it comes down to basics, right? You got to perform all the basic, functions that you're supposed to do, and do it thoroughly, as Julia was explaining. And I think it's the culture, it's the training, it's the expertise, at the end I think is from top down, is how your firm is run. That is more important in our mind. I think there's no tricks. I think it's just to do your basics more thoroughly.
I want to move on to the third topic on communication, collaboration, discipline, and deterrent. Tom, I'm going to go back to you because the SFC in December last year issued an update to its guidance on cooperation with the SFC. And I wanted to hear from you. What are you hoping that updated guidance will produce?
Right. So again, we're trying to move our resources to the more severe problems. And so you can do that a number of ways. You can just close cases and take on the more serious cases. You can resolve those cases certain ways, and then again focus your resources. And this is one of the ways we think we can resolve things. If you look at even the actions that came out yesterday, if you look at any big firm, most of the time they're going to have some problem ongoing, a regulatory problem. It could be a very minor problem, could be a very serious problem, but there's a lot of ongoing problems as we move along. And if they're willing to recognize that, put it behind them, remediate the problem, if there's no client harm, or if there is small client harm and it's been remediated, we're willing to give them a discount off what the penalty we would normally impose, and that allows us, I think, to better utilize our resources. I know one of these cases, one of the first cases we did where we grouped a number of these control problems together, they wouldn't sign off on the settlement agreement because the board that we had given undertaking wanted to sign off first on the remediation plan, which is exactly what we want to happen. So we're getting the highest people involved at the start. We're solving the problem. You still get a fairly significant penalty, so I think we still have a deterrent effect. The action is transparent, so people know what not to do. And I can utilize my resources focusing on those big problems. And I did want to pick up on something David Graham said when he was up here, and I think we should recognize that when we're talking about problems in enforcement, that I think Hong Kong markets are one of the safest markets still to operate on. And some of these, when you hear us talking, we're dealing with some of the worst players, but they do affect our reputation, even the small number of frauds we've seen. So I just want to go back to that, and I think it's very important for our reputation.
Andrew, I wanted to get your thoughts on this question of the incentives to cooperate, sort of the carrot versus the stick of deterrent, particularly given your experience on both sides of the table. How effective is it?
Let me start with where Tom started and then work backwards to Julia's part of the spectrum. The scale that is laid out in that guidance note and that Tom's described is very similar to the scale in the UK. It works well. There is one point of difference that Tom and I were discussing over lunch. In the UK, the clock starts ticking against you for the 30% discount only when the FCA tells you what its case is in a draft form. It issues a document called a draft annotated warning notice. Effectively, it has to say, here's what we think. But that doesn't happen here, and Tom and I were having a discussion about whether you want to add another layer of complexity. It isn't always clear where the regulator finishes up in an investigation. Sometimes it is, but it isn't always. And so provided Tom and his team are clear and people understand the case that they may have to meet, or what the concerns are and the seriousness of those concerns, then I think they can fairly react and they can get the benefit of that discount, and that's to be encouraged. I mean, it doesn't deal with any of the cases involving individuals, or indeed many of the cases that Brian and David were debating in the earlier panel, because they will pick up individual director responsibilities. We're effectively talking about resolving matters at a corporate level. But the individuals fight all the way, and for obvious reasons. Before you get to that part of the spectrum, though, let me come to Julia's area. If you take a 10-year view, broadly speaking, in all the jurisdictions that Hong Kong would want to compare itself to, there was a tendency for things to much more quickly go into enforcement. Things that historically would have been dealt with as supervisory issues went straight to enforcement for punishment. In the context of the financial crisis, that's understandable. And indeed, no doubt, there was a need for some toughening up compared to light touch regulation and the things that were fashionable leading up to the crisis. The pendulum swung a long way, and in some jurisdictions, I think, too far. And so when people, even now, who sit at the top of organizations, want to know whether they are required to report something, the dialogue goes something like this. Do I have to report it? Yes. Will I get any credit for reporting it? Not much. You're required to. Will I be sent to enforcement? Probably. Can you think of a reason why I don't have to report it? Now, I'd put it in a kind of lighthearted way, but actually the tension is enormous because people at the top, the managers in charge, don't feel that there's any option in some jurisdictions but to go straight to enforcement. Now, I know that Tom and Julia are working very hard to rebalance that, and that's not a criticism of what's gone before. They're working very hard on getting the balance right and making sure that, as Tom said, he and his team focus on the important cases, the ones that really matter, and that they're dealt with quickly and efficiently and the messages get out there. And it isn't an issue that's confined to Hong Kong. It's a more general issue, and it's a really important rebalancing, I think.
I'd like to chip in. We are rebalancing not because of the issues that you talk about. It's more, what is the best outcome? From my point of view, if I go into an inspection or through monitoring, we have discovered breaches and misconducts. Of course, there's a process in which I refer to Tom.
Yeah.
And there are very much evidence and based on a couple of criteria. But I would also ask, what is the best outcome for changing this behavior?
Yeah.
If it is something like quite reckless kind of risk management issues, then I would immediately, this is where I borrow that term again, front load the
Julia,
regulatory
we're
action.
completely in agreement on that.
So I would go in immediately and ask that the company undertakes or impose licensing conditions as it sees to stop that behavior.
Yeah.
And that may be it. So.
Yeah.
But then, depending on, of course, on the facts of the cases, whether it would go to Tom's area or
I mean,
not.
you can't walk into a police station, confess to a murder, and expect to be thanked for it, right? It is, of course, a question of the seriousness and the facts.
Yeah.
My point is completely in agreement with yours. I think that people were not approaching it in that way. There was a political and other pressure that was driving it straight to enforcement. And, of course, I appreciate that the analysis I went through is wrong. The requirement to report is the requirement to report. It's not in any way qualified by whether or not you're going to go to enforcement. I just observe that is the way the mind works.
But just so you know, you understand how it does work, though, like Brian, Ho, and Julia and I are in touch constantly. Yeah. So if she sees a high priority matter, he speaks to me right away. I downgrade something else I'm doing for her and work on that. Same as Brian. So it's a constant reshuffling of priorities. But I think we're getting at the tough stuff as quick as we can.
Tom, I want to raise one question about what you've been saying. That's actually been raised by a member of the audience, and I'll add a little bit to it. So the question from the audience was, when does the expectation that a firm self-report actually kick in? The requirement technically under paragraph 12.5 is that immediate notification is required when a material breach has occurred, but often a firm needs time to ascertain actually whether a breach is material and to get information on the matter. And in addition, I've spoken with some firms that say very often there's a situation they have where it's not even clear to them whether, in fact, a breach has occurred. But they do feel that it's appropriate to go to the SFC and have a discussion. So they'd like to do that, but they don't necessarily feel welcomed to have that discussion. That the reaction that they get is, if you have something to report, please come and self-report. Send something in writing, let us know what it is. And many firms feel that that's not quite the appropriate way to deal with the situation. So how do you deal with that? Do you welcome that sort of discussion?
Yeah, I don't understand that about just file a report with us. I haven't heard that. But I always tell the firms, if you're in doubt, give us a call and say you're looking into it. And if we find something, we'll come back to you. If not, we won't. And it's very easy. But we always have. I mean, I've got those group of firms I know are the good firms, and I know I can trust them, and I know they'll do that. And they're the ones that call me and do that. So if you want to be treated, I think, more respectfully in that process, you've got to give us a chance. And you know, we're busy enough ourselves to overreact and jump on a whim of someone's that there may be a problem. We wouldn't want you to do some investigation, but you've got to at least let us know what's happening. And sometimes we can give you advice. Sorry?
Can we get a mic that Tom can use? Because I think this one is.
Yeah, I very much agree. I haven't heard of it. In fact, we had a case in which the self-report came to us like after they spent 1.5 years investigating. And when it comes to us, we are a little bit upset because you should have told us that it happened, and we will give you time. And certainly, you need to spend time to do your own internal investigation. So, if that is a misconception in the industry, I'd like to clarify that we do welcome early alerts, even if you don't have all the facts of the case. In most cases, I guess the firm would like to get to the bottom of it before reporting. But sometimes, if it's 18 months later, this is not what our expectation.
Fair enough. Greg?
Yeah. Obviously, there are many cases that it become an easier decision, especially, but in other cases, in some cases at least, very experienced, well-trained professionals, they don't agree with each other. So in those cases, it's not as straightforward as our regulators would require to do. So can I have one recommendation? I think it will help the whole industry if we, SFC can publish some statistics on, all these self-reported in terms of category, in terms of frequency, so that many of these cases where the experienced professionals debate, there's some guidance because there is a different way of judging materiality, right? I mean, most cases are clear cut, but in cases those are not clear cut, and these will certainly help out.
We go back and think about it, but we are certainly revamping the self-reporting portal, and then we are revamping the form. I think we can clarify in that form what is expected, whether it needs to be fully investigated or not.
Let me just say, Julia, that as you do that, come across Payment Services Directive number 2, the requirement to report significant cyber incidents. There's a definition of what a significant cyber incident is, and you have 3 hours to report, and you have to use a form which takes 4 hours to complete. But to Greg's point, actually cyber incidents are the toughest often to judge. Who, how far, what have they got, and who's behind it. But the trend there is, in fact, as it started in Singapore and now it's gone to Europe, to set a time limit. The guidance on what's significant isn't too bad. The form is ridiculous.
I won't put that in. Report yesterday, something like that.
Yeah.
Well, Andrew, thank you for bringing up the subject of tech, because that's a good excuse to go into our last topic area. I want to go back to something that was mentioned in the first panel about Hong Kong's ability to keep up and promote, keep up with technological innovation and promote it, and striking that balance with protecting investors and protecting the market. There are some critics who say that Hong Kong is not doing enough to promote innovation, that regulation may be making it too difficult. Julia, I know you have some strong feelings about this, but perhaps you could address this, and clearly one area where this has come up just recently and topically for many intermediaries is the recent consultation on online advisory and distribution platforms.
Yeah, we are, in terms of technology and innovation, now clearly this is going to change the way in which financial services are being delivered. And as the regulator for the delivery of these regulated activities, then we certainly would look into fintech and see how that is being applied. Now, when we get into the discussion of whether we are promoting, whether we are standing in the way of fintech development, I don't think there is one, we are providing the policy platform, providing rules and codes for technology to be used and in order to deliver better financial services. We all support the principle that it will help financial inclusion and more robust in the delivery of services. So there is actually not people like to pitch it as a balance between innovation and then investor protection, but I don't really see it as a balance. But we see it as applying our principles of investor protection when these technology is being used. Now, so the approach, as you ask us, is basically we are technology neutral. We are principle-based supervisor, which means that we use the same principle which we apply to protect investors regardless of whether they are delivered face-to-face or in an online environment. Now, we reckon that some of the rules, including suitability, they are written at a time when most of these products are being sold face-to-face through RMs, and now we certainly see a sea change in that area. And so that's why we have this consultation, which basically is a clarification and updating on of our suitability requirements and how it is going to be applied in an online environment. Now, there are several strands of work that we are doing along this line. One is we're reviewing the order placement methods, that is, whether instant messaging tools, the social media, WhatsApp, WeChat, can be used for customer to place order. Now, but in so doing, we have to ensure that the key principles that we have been of record keeping is being observed. That is, there is a centrally controlled record. There's completeness, there's security and compliance monitoring, and we are looking into areas, and we think that we are able to do it. But we will put out, when we do, we're going to put out a circular on that. And we are also increasingly firms are using outsourcing to cloud services. Now, this is an area in which we are studying. There are a lot of implications in enforcement and regulatory implications, but we are indeed looking into the accessibility of data, which is important, and for compliance reasons and for regulatory reasons, for those data to be stored in clouds. Now, there are the top risks that most firms have is cybersecurity. We already issued a guideline on the 20 baseline requirements, two-factor authentication, and so on. I'm not going to repeat here. And the last part is on data analytics and RegTech. Now, RegTech helps firms to comply with our regulatory standards. It also helps us regulators to do our compliance testing. And we have been deploying enhanced data analytics to detect deficiencies. And then what our experience with the firms is it took them a lot of time in order to come up with a set of data which comply with the data standards. And so we are embarking on an initiative in talking to the industry and developing a common industry standards for the format of trade-related data. That is, in the future, firms could use this standard data to store their transaction data and send to us for compliance checking and for detecting deficiencies and exceptions reports. So I think that the industry, we'll be talking to the industry. I mean, these are the areas in which it shows that we are moving and we are trying to move with the times, and we are updating our way in which to allow that technology can assist with compliance and can assist with our delivery of services.
Greg, can I ask, how do you think of that approach? Do you think the SFC is taking the right approach towards technological advances?
There's no doubt, in this advanced technology time, clients actually need better convenience and consistency and the whole overall experience of financial services. And we as an industry need to move fast because we saw this IT interaction actually disrupted many industries, and many firms died the way of dinosaurs. So we're constantly reminded of that. But at the same time, so we got to move fast. I think we maybe as an industry maybe is not up to that speed. We got to figure out a way for online account opening and suitability and all of that. I think we got to achieve all of that. But at the same time, I think I agree with Julia that at the end of the day, there's finance at the end of the financial services at the end has a lot of basic elements. You actually need all the experience that we financial industry provides, whether it's investor protection and suitability and all of that. We certainly don't want to get into a situation where in many places P2P fiascos that lead to tremendous amount of investor losses that happened over the last few years, especially in China. Even Chinese regulators call these financial chaos. So we certainly tighter regulation is certainly needed. But there is another aspect that I think we as an industry are facing. I think last year there was an Economist cover page talk about data is the new oil. There is a natural monopoly to it. When you have a giant IT companies that basically collect data on everything, and they have artificial intelligence programs to actually identify all these needs, and how can we compete, right? So we certainly, as an industry, we have a higher standard of client confidentiality and privacy protection, and in this space, how do we compete? So this is not an issue for financial services; it's for a lot other industries as well. Maybe the answer is to break up Google. I don't know, but so this is a true challenge that we are facing.
And just to say, I think you didn't say it explicitly, but clearly there is a difference in the approach to privacy protection between mainland China and in Hong Kong, which clearly is going to have an impact on the development of some of these sort of big data-driven services in the respective jurisdictions.
Yep.
On the use of big data, Tom, is there some way that, and maybe Andrew, you can weigh in on this too, that the regulators are trying to make use of all this massive amounts of data that's now available to regulators in order to try and identify risk or any kind of misbehavior in the markets that isn't currently being taken advantage of.
Yes, and that's part of this project we are looking at, because I think it does affect our surveillance systems. I think the surveillance systems now are still pretty linear. We look for blips in the market and unexplained blips, and then why wasn't there any news before that? Who traded? Sometimes we look at multiple parties, but I don't think it's as sophisticated as it could be. Plus, we're going into client identification now, so that gives us another layer to look at. So I think that's the next wave is bringing in big data to try to understand things on a much more comprehensive basis. And I don't think we're there yet, but we're definitely looking that way, and we've definitely got our eye on that.
Yeah, I think the French have led the way in terms of investment on it, and they are going beyond the market surveillance that Tom describes to try and define what normal behavior would look like, and then to see if they can spot aberrations. And a number of the bigger international banks have tried to do the same. Actually, they've all, broadly speaking, failed so far. The data isn't in quite the right form. They struggle to define what good should look like, except by working backwards from actual breaches. So they're all moving towards pulling together disparate bits of information that historically they'd looked at in isolation. And it may be things as apparently benign as when someone arrives for work and when they leave at the end of the day. Do they do their training? Do they take their 2 weeks annual leave? Are there cancels, corrects, and amends that look like an unusual pattern? How many times do they get close to risk limits, etc.? Then frequency of emails, even telephone calls. And so they're trying to pull all that together. The best of the banks are the ones that have had the biggest rogue trader scandals, as you'd expect. But everyone is struggling with that. I mean, in 5 years' time, people will give their traders wristbands, and they'll be able to test heartbeat rates, and they'll be able to say whether they've crossed a Chinese wall from a public... All of that will happen. I think before that, though, and coming back to Julia's aspect of big data, and to pick up on Greg's themes, Hong Kong has three, I think, big policy choices. Julia's consultation is completely in line with all the international stuff. What's complex, what's not, how to think about what's a recommendation and when suitability kicks in. It still begs some questions. The first one came up in the first panel. Are you going to change the nature of the relationship down the manufacturing distribution chain to put more emphasis and pressure on the manufacturers? That's happened in Europe under MiFID II. Is Hong Kong going to follow? With all the implications that has for cost and liability. That'll be the first one. The second is, will Hong Kong facilitate the use of cloud outsourcing and chains of cloud outsourcing? And at what price? What kind of due diligence? What access rights to information that there's been a cyber incident? What rights to go in and find out what's happened? All of that. And that's causing a lot of repapering of arrangements with outsourced providers in Europe. But it's not always an even dialogue, because if your outsourced provider is Google or IBM, they're very powerful. So the regulatory expectations and standards are changing the debate there. And the third is open banking. Now, in Hong Kong, that's going to be mostly for the monetary authority, but actually the beneficiaries will largely be for those who are regulated by the SFC. If you can get better access to information from existing bank relationships and use that to structure your advice and to make sure that the product that you're recommending is suitable and the client has the affordability for the product, and then you can build that onto platforms, you can close all sorts of advice gaps that currently exist and get a much better outcome for clients. Actually, you could also get a much worse outcome, because misusing that information could target the suckers. And so the European decision, and Australia's now following, is to go for open banking, to work out the protocols that allow one firm to demand information from another and be authenticated and require that information to be given. But it takes a lot of work behind the scenes. Hong Kong can probably jump in on the standards that have been now agreed at the European level. But unless it does, then I think you're back in the other area that Julia and Greg touched on, of companies which already have an enormous amount of information that they've gathered in other contexts, WeChat, for example, who can then use that information to target their own products and services and cut out the existing intermediaries.
Julia, any insight you can give us into whether the SFC is thinking along these lines?
I think the fact that the tech giants, I mean, the reason why they are powerful and will be disruptive to the industry is because they already have a lot of data and a lot of customers, and they can analyze and decide whether you have this needs to borrow. So I think a lot of initiatives on the side of HKMA, the open banking data, the virtual banking, that when they come, I think the local industry should be geared up, should be really the competition angle. They would need to jumpstart and be prepared for this age.
I do want to take the rest of the time that we have just to address some of the questions that came in from the audience that we haven't already covered. We have managed to sneak a few in there. I'll take the one that I think I liked the best, the way it was phrased. This is a question for Julia and Tom. Can the MIC regime be summarized as, quote, "we know where you live," unquote?
Well, I'd just make a comment because, Andrew, I don't know if you were as accurate in your comments about the MIC. It was an enforcement from, it was Julia's initiative to bring this in. But I don't think we should have any qualms that we'll use it as an enforcement tool to identify people who are responsible.
Sure.
And
it's about accountability.
Right, right. So it wasn't brought in for a pure enforcement purpose, but it will surely help us on the enforcement job.
I think the question is, they have nowhere to hide, or whether they, I guess it's the alignment of the RO and those responsible for taking a decision. I have many ROs who come to me and said they like this MIC because in the past they've been appointed to the RO job, but then the real decision makers are somebody several grades above them who do not have any formal responsibility. Now they have to be named in MIC, and they have to step up. These people really have to step up and be accountable for their action.
Okay. Sticking with the deterrent theme, another question that came in was, are sanctions in Hong Kong tough enough to change the behaviors of bad actors? And I think that, to a certain extent, speaks to the fact that Hong Kong does not follow down the same path as, for instance, regulators in the UK or the US in terms of the monetary sums that are levied against players that fall afoul of the rules. But on the other hand, Hong Kong has other methods at its disposal. Maybe Tom, from your perspective, what do you think?
I think that it's difficult to say what's most effective. I think there's big debate whether huge fines work, whether individual accountability works. Who gets punished with these fines? Is it the shareholders? There's all kinds of debates on that. I think here we could raise our fines a bit. I think with the HSBC case with the multiplier, obviously fines will go up, and I think people are understanding that, you can't have, large client harm and no results stemming from that. So I do think the fines will go up. I think personally, individual accountability is probably the most significant, and because it's important. And I think we have to use that. Again, I think we have to be careful the way we use that and use it responsibly.
Andrew?
Well, often people are not comparing like with like. Tom's armory makes much greater use of redress strategies than, for example, even the SEC. The SEC levies a penalty and then it can distribute some of that to those who are victims. You've got to look at the package that you get here. Yes, the penalties are lower, but you then have to look at what level of individual accountability has been weighed on someone at the top. And Hong Kong is still pretty good at making clear that someone is no longer required. And so, people do suffer personal impact on their careers as well.
I think we'd be remiss in a discussion involving technology if we didn't address the issue of crypto assets. So the audience has raised the question, since I neglected to do it myself. What is the SFC's stance towards the development and sale of cryptocurrencies, we'll call them crypto assets, by or crypto asset products sold by intermediaries? Julia, do you want to take that?
Yeah, sometimes they mistake me for regulating. The only thing that I regulate is crypto, but it's not. We have been stepping up our regulatory action and enforcement action, and this is an illustration of how well I work with Tom. When we now, I don't have to go through all the fraud risk and cyber risk of these ICOs, but the idea of a token which promises access to a service in the future, and then they're offered to the public with a very a white paper with no details at all, no projections, no profits. No other investment products are offered to the public can do that. If you have if it's listing in the market, or a retail bond, or a mutual funds, you go with a lot of regulated formats and audited by professionals and sold by licensed individuals. So we certainly think that this is a huge investor protection issue, consumer issue involved, and we've, to the extent that it's a security, and we look into every ICO that we get hold of, and we take regulatory action. And we have successes. In a recent case, there was a ICO which was issued by a company offshore, and we wrote, Tom's team actually wrote a warning letter, and as a result, the token that was bought by the Hong Kong investors, that was unwound, and the website is no longer accessible to Hong Kong investors with a Hong Kong IP address. We also took action against several cryptocurrency exchanges and asked that once we took action, they removed the security tokens from the shelf. I think we should continue to do more, and we will be doing more. But it doesn't mean that there are other issues about investment funds which invest in cryptos.
Surely.
That's a different. There's a different
if you look at how
class of issues.
There must have been 100 regulatory announcements on this topic in the last 3 months. And they fall into two categories. The warning, Julia's issued a warning. I mean, some others have been more extreme in their warnings, but anyway, the warning has come. And the other is, can we regulate it?
Yeah.
And the trouble is that, yes, sometimes you can fit it into a securities box, sometimes you can fit it into a collective investment box, but sometimes you can't. And so all the regulators, I think, are struggling with that. Do they need to think of a new way, or do they need new powers, rather, to effectively regulate the range of things? Because it's not difficult to construct it in a way which makes it difficult to characterize it as either a security or a collective investment. So that needs looking at, not just here, but everywhere.
Tom mentioned the HSBC case and the use of multipliers. So we have one question from the audience. Is that going to be a precedent for what we'll see from the SFC in the future? Is this use of multipliers sort of the wave of things to come?
It depends. I mean, we're looking at it. That's, it's fairly case specific, where you have an identified list of complainants. You can isolate a breach to each of those clients that were whose rights were violated under the Act. But I mean, if you could extrapolate, you could also use it for, say, market abuses, where you've got multiple victims in a market. We're thinking about it, but beyond that, we're just still analyzing it right now.
Okay. One person asked whether, under the front-loaded approach to regulation, will there be a change to the dynamics between intermediaries and enforcement?
I think the change has already happened, and including corporate finance. I think we're very on top of what we're seeing on the market out there, and we're working together very hard to make sure our markets remain safe.
Julia, do you want to add anything? Okay. Good. I think that pretty much wraps up the range of topics that we aim to cover today. So thank you very much to the entire panel.